These blogs has been, over the last several years, to try to educate the consuming public, those who might have a case or those who are wondering about the lawsuit and the litigation process. As in any profession, there are sometimes misconceptions about what happens. And in the past, I've discussed notions of how long a case takes, and certainly there are no hard and fast rules on that. Another notion is we're dealing with typically the law of negligence. And the law of negligence is what is the duty of care? Does the defendant owe a duty to the plaintiff? Was the plaintiff injured? Was the injury a proximate or legal cause of that negligence? And those questions need, of course, some elaboration, and the facts have to fit into those legal constructs. I had a client recently say to me, have we proven negligence yet? Well, the case is still, within its first year, and there is no official time when you can say you've proven negligence. You know it when it happens. You know it when you've gotten good admissions in a deposition, or you've seen some good paperwork that helps you to be confident that you can establish negligence. But there's no red light, green light that will tell you, okay, you've now established negligence, you may go on to damages. It isn't quite that susceptible of a rigidity or order in that way. Both liability and damages can be ongoing, can be evolving. Certainly we know a serious injury is ongoing and evolving, and we still start the lawsuit process during that, because at the conclusion of the process we hope to have a medical opinion or several medical opinions as to what the future will hold for the client. In terms of negligence, in terms of the liability portion, there's always more you can learn and do learn so that you will ultimately be in a good position to present the liability portion. Now we know, for example, in a premises liability case, that the law in Massachusetts is a landowner owes a duty of care to all those lawfully on the premises. And that's what we start out in such a case, a premises liability case, knowing what the law is, and we try to fit our facts and ultimately our damages into some sort of system that will allow for compensation. And another misconception, this one held by the defendants, the insurance companies, is they think if they simply get a statement that incriminates your client as to how an injury or an accident occurred, that they are home free. And I say that's absolutely not true. If you have a client who is or appears to be honest, who perceived the event, can narrate it, and can narrate it in a clear way and in a believable way, then you indeed can help to show negligence on the other side. And the mere fact that one or two people disagree with your client may mean nothing. It's a credibility contest, and as the law says, experts don't decide cases, juries do. And in the same way, lay people, lay witnesses who say things don't decide cases, juries do. And if your client is credible and can be believed to carry the day with the jury, then you can rest assured and rest on the statements of your client and go into that case with confidence. Thank you.